I suspect, okay. I suspect that probably most of you have experienced mediating with self-represented litigants and probably could teach this class. But nevertheless, we're offering this class because, as you know, there's a requirement for being on the ADR panel for taking this class. With me today is Maggie Grover, who is a native Vermonter who came to California in 1983, immediately after graduating from law school. She has worked in employment law and litigation since 1984, and mediation has been part of her practice since 1988. When she's not working, which was like this morning, Maggie can be found cycling the hills in Contra Costa County and Alameda County or rowing the Oakland estuary. And so we're very pleased to have Maggie with us this afternoon to address issues. By the way, she wrote an interesting article for the Lawyer magazine, and that's one of the things that she'll be talking about today and will be in the materials. And then also today is Malcolm Sher, who was born and raised in Rhodesia, now Zimbabwe. He earned his law degree from London University and was admitted to practice in the UK in 1972 and in California in 1976. And as such, he is the senior here today. We've made sure to point that out to him.
Just remember it.
After litigating at both the plaintiff and defendant bars, he transitioned to full-time mediation and arbitration in 2010. Malcolm's active mediation practice focuses on high emotion and cross-cultural disputes and covers real property, landlord-tenant, wills and trusts, business, and partnerships, professional liability of real estate agents and brokers, employment and personal injury cases. He is past president of the Mediation Society and has both written and presented widely on the subject of mediation. I went to mediation school with Malcolm 20 years ago at Stephen Rosenberg. And so we have a history there, having started our mediation education together. I've been an attorney for, no, it's been almost 45 years. And I have been in the ADR section and was actually the founding president of the ADR section way back when, and have had the ability to serve with both Maggie and with Malcolm in that regard. My practice essentially is wills, trusts, estates, administration, and conservatorships. And so I don't really get that many self-represented litigants. And so I don't have the same kind of experience that either Maggie or Malcolm do. And so it'd be interesting to hear their perspective on this. So what we're going to do this morning, or this afternoon, just so you know, is we have an agenda that's going to go over California law applicable to mediators' ethical duties in dealing with self-represented litigants, which can be found in the California Rules of Court starting at section 3.850 through 3.868. And so we're going to go over that. And then Maggie's going to address those same sections from her perspective based on an article that I mentioned previously that she wrote for the Contra Costa Lawyer magazine. And then Malcolm is going to talk about what the court tells SRLs, self-represented litigants, about mediation. And then Maggie's going to speak about the overview of working with self-represented litigants. And then Malcolm's going to address the pre-mediation conference. And then the joint session will be addressed by Maggie, and the private caucus will be addressed by Maggie. And then I will complete things in terms of talking about the communication challenges in dealing with self-represented litigants, and also closing the deal and preparing the settlement agreement. And then we will be taking questions, and Maggie is going to monitor the chat. Is that right, Maggie? So that if you have a question, do you want to address that? How are you going to do that?
We'll monitor the chat. And if a question is there, I will interrupt whoever's speaking and read the question if I can do it gracefully.
I'm sure that you can and you will. Okay, so with that, let's get started. So the first thing that we are going to talk about is the California law applicable to mediators' ethical duties in dealing with self-represented litigants. And I had mentioned the California Rules of Court, and really the ones that are going to be of most interest here start with Rule 3.853, which is voluntary participation and self-determination. So a mediator, all of us, must conduct the mediation in a manner that supports the principles of voluntary participation and self-determination by the parties. And so for that purpose, we are required to inform the parties at or before the outset of the first mediation session that any resolution of the dispute requires a voluntary agreement. We all know that. That's what we tell people usually in a joint session about one of the benefits of having mediation as opposed to the litigation process and track is that they retain control and that this process is completely voluntary. And then second, we have to respect the right of each participant to decide the extent of his or her participation in the mediation, including, hopefully not, the right to withdraw from the mediation at any time. And then finally, to refrain from coercing any party to make a decision or to continue to participate in the mediation. And isn't that kind of like a fine line? Because all of us have probably dealt with the situation where somebody is thinking, this isn't working for me and I think I want to leave. And it's kind of like, then there has to be a discussion about, so what's the best case scenario if you go forward doing this, and what's the worst case scenario if you leave? So it's that kind of an analysis. And so while we're not coercing any party to stay and mediate, at the same time, we're hopefully trying to get them to think about what their interests are and what would serve them best. And, in the end analysis, it's their case. And if they decide they want to do something else, it's like, okay, So the voluntary participation and self-determination are fundamental principles of mediation that apply both to mediators in which the parties voluntarily elect to mediate and to those in which the parties are required to go to mediation in a mandatory court mediation program by court order. Although the court may order participants to attend the mediation, a mediator may not mandate the extent of their participation in the mediation process or coerce any party to settle the case, which really would be pretty difficult for us to do in any event. After informing the parties of their choices and the consequences of those choices, a mediator can invoke a broad range of approaches to assist the parties in reaching an agreement without offending the principles of voluntary participation and self-determination, including encouraging the parties to continue participating in the mediation when it reasonably appears to the mediator that the possibility of reaching an uncoerced consensual agreement has not been exhausted, and suggesting that a party consider obtaining professional advice. For example, informing an unrepresented litigant or party that he or she may consider obtaining legal advice. And that's really helpful, right, from our perspective, because when you're mediating with someone that has an attorney, that attorney can have a confidential conversation with their client about the risks and potential rewards of not arriving at a settlement agreement and proceeding down that litigation track. And that's really hard to do with a self-represented litigant. So moving forward then, the next rule that's of importance to us, and one that we have to deal with all the time, is Rule 3.854 regarding confidentiality. So we're required at or before the outset of the first mediation session to provide the participants with a general explanation of the confidentiality of mediation proceedings. And I know that all of us do that. I mean, typically, we're advising the participants of, frankly, what our training is so that they know that this isn't our first rodeo. And then also talking about what we have done in the past and our approach optimistically. This is a case that can settle. We just need to work at it and find that sweet spot to be able to make this an agreement that everybody can live with, and then talk about confidentiality. So if after all the parties have agreed to participate in the mediation process and the mediator has agreed to mediate the case, a mediator speaks separately with one or more participants out of the presence of the other participants. And that's always difficult because then they think that you're talking against them. The mediator must first discuss with all participants the mediator's practice regarding confidentiality for separate communications with the participants. Some mediators start from the premise that everything that you say to me, I'm going to assume I can convey to the other side unless you tell me that you can't. And the converse to that is that everything that you say to me is confidential, and I won't say anything to the other side about what you said to me unless you tell me that I may. And so you have to kind of decide what works for you. I think there's more risk in the second approach because you never really know, they never really know exactly what you're saying to the other side and whether or not you're saying secrets, and that might make them reluctant to talk to you and give you the true approach from where they're coming from regarding what their interests are and also what the facts are and what's happened. So that's an important consideration. Moving on, the issue regarding the competence of the mediator is an important one. A mediator has to consider and weigh a variety of issues in order to assess whether she or he has the level of skill, knowledge, and ability sufficient to make her or him an effective mediator in this particular case. So it includes whether the parties were involved or had input in the selection of the mediator, had access to information about the mediator's background or level of skill, knowledge, and ability, have a specific expectation or perception regarding the mediator's level of skill, knowledge, and ability, and so forth. So those are things that we have to think about and make sure that we convey to that self-represented litigant so that they have a full picture of who you are, how you're going to approach this mediation, the issue of confidentiality, because we have to build their trust, don't we? I mean, if they don't trust us, we will never get to first base. And that's extremely important with a self-represented litigant, more so than a litigant who is represented by counsel. So the quality of the mediation process requires procedural fairness. A mediator has to conduct the mediation proceedings in a procedurally fair manner. Procedural fairness means a balanced process in which each party is given an opportunity to participate and make uncoerced decisions. A mediator is not obligated to ensure the substantive fairness of an agreement reached by the parties, which is kind of important because you may have the opinion that this isn't exactly the best deal that this self-represented litigant could get. But this is not your case. It's not your mediation. The process has to be fair to the self-represented litigant, and they have to come to the conclusion for themselves whether this is in their best interest or not. So that's different than your objective analysis and opinion as to whether or not the agreement reached is, in your opinion, in the best interest of that self-represented litigant or not. So in addition to the requirements of Rule 3.853 with voluntary participation and self-determination and confidentiality, and of this rule at or before the outset of the mediation, the mediator must provide all participants with a general explanation of the nature of the mediation process, the procedures to be used, the roles of the mediator, the parties, and the other participants. And that's important. A mediator has to inform all participants at or before the outset of the first mediation session that during the mediation, he or she will not represent any participant as a lawyer or perform professional services in any capacity other than as an impartial mediator. Subject to the principles of impartiality and self-determination, a mediator may provide information or opinions that he or she is qualified by training or experience to provide. And so there's this very thin line about representing a person as an attorney and still having the ability, even if you are not representing them, which a mediator, of course, is not doing, to advise them of what your understanding of the law is and how it might apply to these facts, because that's kind of the information that they would have gotten from their own attorney had she or he been there. But if they are not there, then they have to have this knowledge to assess their risks versus benefits in order to determine what's in their best interest to agree to as they move forward. A mediator may recommend the use of other services in connection with the mediation and may recommend particular providers of other services. However, a mediator must disclose any related personal or financial interests of recommending the services of specific individuals or organizations. duh, I think that you should go and talk to this CPA. And oh, by the way, this CPA happens to be my sister-in-law, so, you can't do that. And that. Settlement agreements consistent with the things that we just talked about here. A mediator may present possible settlement options and terms for discussion. A mediator may also assist the parties in preparing a written settlement agreement, provided that in doing so, the mediator confines the assistance to stating the settlement as determined by the parties. You cannot add terms, conditions, and so forth. That's a tough one, because when we talk about this issue of creating the settlement agreement, at the end of this webinar, I'm going to talk about preparing a settlement agreement, because I almost always do it. But when you start talking about doing this in the context of a self-represented litigant, gosh, do we put in a waiver of 1542 and they didn't negotiate that? And, how do we deal with that? And it's like, no, it's got to be the terms that they agreed to in their settlement, and you can't go adding things to that. So that's a tough one. Maggie, maybe I could call upon you at this point to talk about this issue of ethics of mediators dealing with self-represented litigants from your perspective and your experience that encompasses what you wrote in your article.
So thank you, Ron. I think there are a couple of points that you made that I'd like to follow on. One is the distinction between I'm going to disclose everything and I'm not going to disclose anything unless you tell me you may. And I actually use the I'm going to disclose everything if both parties are represented. That's my go-to position. I think that can be unfair to an unrepresented litigant because she or he may not understand what is really harmful to their case. And if they blurt something out and the other side asks me what their thinking is on that point, I feel compelled to explain it if the person's given me that information. And so I think it is procedurally more fair to say, I'm not going to disclose things unless you specifically give me the authority to do that. Now, then it becomes a question of whether you can tip things one way or another by asking the self-represented litigant, do I have permission to share that if it is something that's going to help you get the case settled or settled more favorably? So you have to be really clear and careful that you're not tipping the balance either way when you're asking what you may and may not share. Another thing that I have done a lot of thinking about is what tools can I really use with the self-represented litigant that I might not use, that I use regularly that I might not use with a self-represented litigant. And one of them is asking questions. If you have an attorney in the room and you start asking, what's your best case scenario? What's the impact of this fact or that fact on your case? What's their best case scenario? The attorney is going to be able to respond to those. Have you thought about this? Have you thought about that? And questions are not always, particularly if they have a legal underpinning, are not going to be understood by the self-represented litigant, and they're going to feel uneasy. So I think you have to take the questions down and give them more open-ended opportunities to discuss. What is your case about is a better question than have you thought about, or what are the implications? And what legal research have you done? What is the law as you understand it? Or have you sought any advice on the law and how that's going to apply to this set of facts? If they are just not getting the applicable law, I think that I can explain the law, but not really tell them how it's going to apply in their particular fact situation. In California, my area is employment. In California, all employment is at will. That means you can be fired at any time unless you have a written document that says you can't. Do you have such a document? That's a kind of question that I'm comfortable asking, giving them a basic explanation of the law and letting them apply it to their own situation. And then I can talk about things like the basics of the Fair Employment and Housing Act and what facts do you have that show you were treated differently because of whatever they're complaining. So it is an explanation, but I'm not applying, and I wouldn't want to apply the law to their facts. Another line that I use with attorneys is, I am concerned in your case about thus and such. And I can't really say that as well to a self-represented litigant, because I am concerned that your case is not going to get past summary judgment is really more of a statement of the law. It's not really my opinion. And it's going to be extremely prejudicial to them if I start announcing that they're not going to get past summary judgment. They're going to, if they understand what not getting past summary judgment means, and I will explain it, then I've really put the thumb on the side of the person that's brought the motion for summary judgment, or the company that's brought the summary judgment motion. So back off in terms of vigorous expression of your opinions, and I really avoid applying the law to the facts. You can ask them what their concerns are, but it may not get you a lot of helpful information.
So Maggie, a question was raised
Oh,
about whether telling the self-represented litigant this information in this way might cross the line, becoming an advocate as opposed to, let's say, an educator with respect to what the law is.
I think that's a really fine line, and you have to think carefully about what you're going to say before you say it. Can you read them the black letter law? Absolutely. I think that's permitted expressly, but giving them an opinion as to how it applies in their case gets very close to crossing the line. And if you say you're going to lose, then you're persuading, or this is a very strong case, then you're doing much more persuasion than you should be as a neutral.
Okay.
And all of it, I think you want to preface, I am not your lawyer. I think it would be a good idea for you to have outside counsel to consult with you in making your decisions today, or at least an outside person who's familiar with this area of the law. It may not be a lawyer, but have somebody who's going to consult with you, because I cannot represent you. I cannot tell you how things are going to come out, and I cannot be your advocate. I can explain your position to the other side, and I can explain the other side's position to you, but I can't be an advocate for you. And you want to preface a lot of your discussion with that.
Worst question in the world to receive from a self-represented litigant: what do you think I should do?
We're going to talk about that a little bit later when we're in private caucus, because that is a very important subject for private caucus, which I will definitely cover there.
So Malcolm, maybe you could talk to us. Thank you, Maggie. Maybe you could talk to us about what the court tells self-represented litigants about mediation.
Thanks, Ron. Folks, firstly, let me say I'm delighted to see so many people here, and looking at the list, I see the Bar Association has rounded up most of the usual suspects. And, I'm glad to see the names of folks here I've known for many, many years. So thank you for coming. So look, back in 2007, Contra Costa Superior Court prepared a set of documents which are given to those pro pers who come seeking mediation services. And you will get them in your materials, but I'm going to go through a few of them right now. They start talking really about, well, what is mediation and what's the role of the mediator in helping people to resolve their cases. And then the materials ask questions and give information about subjects. For example, how much is it going to cost me? That's one of the questions. And so when judges refer to cases to mediation and through the ADR program, and if you're a panelist on that program, then we're required to give the first 2 hours of mediation time and 30 minutes of scheduling and preparation time at no cost. I don't try to break them down. What I do is I tell them, look, you get 2.5 hours of total time at no charge. And if you go beyond that, then you're going to be paying me $500 an hour or whatever your rate is at that time. The program materials that the court gives to the SRLs talks about mediator qualifications, and says that mediators are required to have training and education and experience, so that pro pers don't think that somebody who knows nothing about any of this stuff is going to try and mediate their case. That is shown in the materials sent out by the court, also about how you go about choosing a mediator and who's on the panel. And if you go to the court website, you can see a list of mediators who are on the panel. Very important point. It also talks about differences in mediator styles, and we all know that mediators have different styles. I tend to be a little more evaluative given the kinds of cases that I have, and how mediators may change their style when discussing the case with the self-represented litigant, and it depends on the kind of conflict that you're talking about. Maggie alluded to some of her style when talking with folks, especially in employment cases. But it tells the self-represented litigants that they should talk to the mediator about what is the mediator's style, and also about it being a voluntary process and that nobody will force an agreement on them. And as mediators, we don't get to make a decision on their case. And then it actually identifies what the mediator's style is, from evaluative to facilitative. We'll talk a bit about what's the value of your case, and how you try not to cross the line, stay in role. And then it tells them that their mediators do have, private caucuses as well, sometimes as joint sessions. And are they allowed to talk to the mediator before they actually come to the mediator session? Talks about the difference between arbitration and mediation, where you can, of course, have ex parte conversations. And then the stuff put out by the Bar Association and the court talk about how the self-represented litigants should put together a statement giving enough information about their view of the facts and how what happened has influenced them, the issues that are important to them, and the damages, if any, that they are claiming. And it talks a little bit about having insurance representatives who may be there, and it talks about that the insurance representatives are required to be there unless they're excused by the judge, so that the self-represented litigant understands that those decision makers who will be making decisions about how to resolve the case are required to be there. And then there's another document which you will see. It's called a mediation worksheet, and it asks the self-represented litigant to actually fill out a form which asks 8 questions about what are the interests and what are your needs, what do you need to have happen here. List where you agree or don't agree with what the other side is saying, and how important is it to you to resolve the dispute today, and how will your life change, what will you gain. All of that is in a special form questionnaire that the court has, which is part of the packet that's given to self-represented litigants. And then finally, there are a list of certain frequently asked questions, which the court has determined over the years that self-represented litigants tend to ask about: do you have to go? Do I have to show up in person? That kind of stuff. Really great stuff that was put out by the court a long time ago. It's given as a package to the SRL, but I'm going to suggest that anyone who's mediating with pro pers get hold of this and read it yourself, because it's going to answer a lot of questions that the litigant, the self-represented litigant, is going to ask, and that you may need to want to answer. There's one other thing about bundling and that rather unbundling services, and that relates to self-represented litigants perhaps getting someone to represent them at the mediation or to prepare them for the mediation, but not show as a representative at the mediation, and maybe somebody who's going to review any settlement agreement before they sign it. So those are all really good stuff that is put out by the court, and I honestly suggest that you familiarize yourself with it, because it's going to be very helpful to you.
So Malcolm, some of those materials are going to be in the packet available to all of the participants today, right?
Yes.
Okay, great. Thank you very much. Maggie, so why do self-represented litigants represent themselves?
Well, it's different for different people. I'm seeing an increasing number of small businesses that just don't have the wherewithal to have an attorney represent them through litigation. They may have been brought into litigation as a defendant. They don't have any insurance for the particular piece of litigation, and most of them, in my experience, have a lawyer that they're calling to give them ideas about shape of the case and what they should do, but they probably don't have somebody sitting there charging them $500 an hour through the mediation. There are people that represent themselves because they think they can do it better. And they may know the area of the law. They may have some experience in a legal background. They may be a dime store lawyer, and they're appearing on their own behalf because they just are comfortable doing that. And on the plaintiff side, there is often an inability to find an attorney. Again, it's a matter of cost. You think you've got a great case. You can't find somebody who is going to handle it on a contingency fee basis. And as a mediator, the most important thing for you to do is to build trust from the very beginning. And I know we're going to be talking about the pre-mediation conference, but that's when you really want to start talking about building bridges with the self-represented litigant. And you can ask them, do you have somebody giving you advice, or why are you here without your own lawyer? Is there some way I can make you more comfortable? And really giving them an understanding of what the process is, and maybe some tips on where to go besides the court packet to get more information about their case and what might happen. Because there's actually a lot online in various court websites that talk about litigation from the self-represented litigant's perspective. And it is very often useful to point them to that information, either for the court, if they're in Contra Costa, point them to the Contra Costa court, or if they're in a court that doesn't have any information about that, then give them some other court website or give them some other resources, and help them understand where they are in terms of the procedure as they're coming into the mediation. And I'm probably walking a little bit into the pre-mediation conference, so I'll turn it over to Malcolm before I take all of his thunder.
All right, thank you, Maggie. So Malcolm, with respect to the pre-mediation conference, and I know we're running a little bit behind here, but so how does that work? Why do we have one?
So look, whether I am mediating with self-represented litigants or with lawyers, I never, ever waive the ability or the right to have a pre-mediation conference. It's a time where you can learn a heck of a lot about the parties' understandings of their case, what their needs are, and what their interests are. So with a self-represented litigant, if I can get that person to get onto a Zoom conference with me, so I can introduce myself, they can see me, I can see them, I can learn a little bit about who they are and what their background is and what they need. I try to do it on Zoom. It's not always possible. The telephone is just fine. And what I do is I start off by telling them that mediation is a process. It's not an event. It started when you went to the court ordered you to mediation. Now you've got a mediator. The mediator's been chosen. And the purpose of having this pre-mediation conference really is for me to allow them to be able to establish some trust in me. so that they are willing to tell me openly about their case, what it means to them, why they're doing this, and to establish, the trust and confidence. And by the way, I always, always thank them at the very beginning for having selected me as the mediator and for agreeing to participate not only in the mediation, which is going to come up shortly, but in this pre-mediation conference that I can learn a little bit about who they are. I'm a great believer as a mediator in learning who are the people and what it makes them tick, what is driving the bus for them. So you talk about things like, at the mediation, there may be a joint session or not, and some SRL say, look, I don't want to be in the same room as that person, or as that company, or as that representative, or as that landlord. I do a lot of landlord-tenant cases, and they don't want to be there. So you need to establish what's important for them at this pre-mediation conference and say, okay, it's perfectly okay for you to be in a separate room with them in another room, and then I will do, the shuttle diplomacy thing, whether it's in person or whether it's on line. When you're talking with the self-represented litigants, establish right away not only the trust, but don't patronize them. Don't talk down to them as the mediator, because they are not going to like the fact that if you're being patronizing to them, they're not going to open up to you. So I always ask them, how may I address you? Do you like to be addressed by your first name, or by Ms. or Mr., whatever it is? You ask them those questions so that you are coming onto their ground, so to speak. Always advise them that they have the right to legal representation, and that depending on the nature of the case, and you may know something about it, you may even suggest, and I've done that, suggest that they might want to consult with a lawyer on certain aspects of the case, whether it's the law or how they might be willing, able to get their facts in if the case goes to trial. I've been asked, of course, from time to time, well, can you give me the name of a lawyer? Absolutely not. You can't do that. But I always advise them that the right to representation exists, whether it's on an unbundled basis or whether they can get someone to come to the mediation with them. And we talk about how do you prepare yourself, meaning themselves, for the mediation. Understand the facts, get your little statement together. It doesn't have to be on pleading paper, nothing of that kind. They can write a handwritten letter to me as far as I'm concerned. But it's going to tell me, what's your overview of the dispute? What happened? Tell me more about that. Oh, really? How did that affect you? What were your feelings about whatever happened? I'm a great believer in asking what-if questions and open-ended questions, whether it's represented cases or unrepresented cases, because by asking these kind of open-ended questions, particularly to self-represented litigants, you're going to get them to open up with you. Again, I ask them whether they have the ability and the right to make a decision for themselves, and are they comfortable making a decision for themselves? Because I remind them that I cannot be their advocate. I'm not their lawyer. I'm not their advocate. I can't give them legal advice on what to do. I can lay out what the possibilities are, or maybe, and then they're going to have to make a decision and select. So one of the questions that I ask is there somebody who will help you or can help you in coming up with the decision on whether or not to settle this case, and if so, on what terms and conditions? In other words, identify the decision makers. And as was mentioned at the bio, a lot of my cases are high emotion cases, and they're cross-cultural cases. So as a mediator, I've studied cross-cultural behavior quite a lot and read widely about it. And so you want to try and understand what cultural overlay is coming into the mediation for the self-represented litigant. And if they are represented, I always ask the lawyer, I say, tell me a little bit about your client's cultural background. Tell me 3 things that I don't know about your client that are, that I'm not going to get from your briefs or something of that case, of that nature. And sometimes in these cross-cultural cases, there's a patriarch or a matriarch in the family, someone who's a sort of a second-tier person who's going to make the decision. And I always ask, is there somebody who has that role in your family or in your life? Sometimes it's a son or a daughter that will help them. I ask them, please bring that person along to the mediation if you feel comfortable doing that, and if they're going to be able to help you in making your decision. And sometimes it's a question of language and the understanding of documents. And if they've got someone who perhaps has a broader education, I encourage SRLs to bring those folks to the mediation, accompanied by a family member or some other representative in whom they have trust. In talking about the mediation statement itself, we call it mediation briefs. I say, look, forget about the word brief because you'll see it in the court materials. I say, write me a letter. If you're comfortable, just bullet point in your handwriting, type it up. Tell me what this is about for you. What happened, then what happened? What are you looking for? Why are you looking for that? What if I can't get for you what you want? How is that going to affect your life? All of this sort of stuff I try to get in the pre-mediation session, while I remind them that it's voluntary unless a court has ordered them to come here. But send me something. If there are documents that you want me to review, send the documents for me. I will read them, I promise you. I did a self-represented case last week where the guy actually sent me about 400 documents. It was a landlord-tenant case. And he'd amassed all of these documents, and he'd filed his handwritten complaint with the court, and sent declarations and all of this kind of stuff in. And I said, I'd like to see that if you're willing to. And he sent me the stuff. I read it. We talked on the phone a couple of times before the mediation session, and the guy got that I was interested in his case, curious about his case, curious about him. Bear this in mind with some self-represented litigants. They may not want to tell you a lot about their personal background.
So Malcolm, we have a question
Yes.
about the support person, and the question is, does the presence of a support person destroy the mediation confidentiality or affect it?
Well, what I do is this. I tell them that if they're going to bring someone along, that person will need to sign the confidentiality. And I have by this time already sent out my pre-mediation letter and my agreement to mediate, which contains a confidentiality provision in it and statement of my fees, and also a statement, by the way, that I am not going to be their advocate and I cannot give them advice. But anyone who comes to the mediation session and is actually present, whether virtually or in person, must sign the confidentiality provision in the mediation agreement. And I explain to them why that happens. I don't think I've ever had a person who is a support person refuse to sign the confidentiality provision once I've explained what its purpose is. Then I will talk in this pre-mediation conference about what my style is. I tell them that, and Maggie sort of broached this a little bit, I do tell them that I will not tell you what to do. I'll not hit you around the head and make you settle the case. But if you ask me a question about what my view is, what my thoughts are, I'm happy to give that information to you. But bear in mind, when you're dealing with pro pers, you need to take a sort of an improvisational approach, because oftentimes they're all over the place. They're coming into you and their thoughts are not terribly gelled. Things are not in boxes, and they're moving around and they're coming back, and it's very fluid, and we need to be extremely flexible. And by the way, extremely patient, because if by what you say, or even by your body language, you suggest a lack of patience, they will not have the trust in you. A lawyer can say, can I talk to you outside? But the pro per is not going to be able to do that. So patience is truly a virtue. And remember this, they're coming into mediation. It's a novel experience for most of these folks, and they are nervous and they're fearful about outcome. And if there is somebody on the other side who is represented by counsel, and they may realize that the table is not really level, and you want to explain to them, you're trying to get a level table, but the other side is represented and they're getting advice. And what you want to do is condition by what you say and how you say, the kind of questions you ask, how important it is for them to understand the process. And then you ask them if they have any questions. Don't hide the ball. I use language like that. Don't hide the ball, because if it's important and it's, the other side needs to know about it, the trial, if it goes that far, is not the time for that stuff to come out. Tell me about it. And if you don't want me to tell the other side, I promise you, I will keep your secrets. But otherwise, I put it all in the hopper, I mix it up, and I try to use that to, assist you folks in settling the case. And then one final comment. I think it's really important. You have to let pro pers know that you work for both sides, because the other side is represented. They are not, but you want to avoid them latching onto you as if you were their lawyer. And so you have to say, look, I'm totally neutral to the outcome. I don't care what the result is here. The decision's going to be yours, to settle or not to settle, and whatever terms they are, but I work for both sides. My job is to sort of broker an agreement, is to help you guys come to an agreement that's not going to be perfect, but hopefully will work for you and allow you to move on with your lives and your business interests and that kind of stuff. So
Thank you.
Terrific. You must have the pre-mediation conference. Do not waive it.
Thank you very much.
Let me add one brief comment on the pre-mediation conference. With the pro per, it is important that you give them small amounts of information because it's all new to them. And a tool that I use after I give them a little packet of information is to say, what questions do you have? Because that suggests that they're going to have questions rather than got any questions, which kind of suggests that they should have gotten it the first time.
Yeah.
And I think that builds a lot of trust.
Good point. So now that we've had this extensive pre-mediation conference, now it's time to start the mediation session. And the first thing to consider is whether to have a joint session. Yes, no, maybe summary joint session because of all of the time that you have spent in the pre-mediation conference. What are your thoughts, Maggie?
Maggie, before you do that, are you going to move forward with the slides so that folks are actually seeing on their screens what subject we're covering?
This is joint session. That's the slide that's up, Malcolm.
I didn't see it there, but now I see it's come up. A bit late.
All right.
Yeah.
I am a big fan of the joint session in most cases. I understand Malcolm's got landlord tenant and they may not want to see each other. I occasionally have real harassment cases, sexual harassment and discrimination cases, and the employee does not want to be in the same room as the person who is accused of harassment or their boss. Those are things that you need to find out before you get into joint session. I like joint session because you're giving the same explanation to everyone at the same time. Who am I? What is my role here? What is my style? How long are we going to keep going today? What tools do we have? And I often find it really helpful to get both parties understanding of where they are in the settlement discussions, because very often people come to mediation after their settlement discussions without a mediator have broken down. But if you can at least get them to agree on what has been offered, what has been offered on the other side, whose turn it is, that is something that will help you move forward in the negotiations. You can talk about information that if the parties are not at each other's throats, you can ask them to share information about their perspective. Sometimes you will hear things, I want an apology, or I want some non-monetary value. And you get that better sometimes in a joint session because they're facing the person that's going to have to provide it. And because we as mediators are not necessarily in tune with what happened to these parties' underlying relationship and why it broke down. And so I think a lot of things can happen in a joint session. If it is somebody that they're two business people, they may want to go forward with a business relationship. Staying in joint session can help them discuss what their future relationship looks like and what options there are. If you are in joint session and things start to go sideways, you need to be on top of that. And in joint session, when one of the parties is self-represented, you need to be ultra aware of the power imbalance that is created by having an attorney on one side and not on the other. And so that may be a time where joint sessions have to be terminated early, or you may take the self-represented litigant out to another conference room and say, are you comfortable continuing in joint session? Is there something that is going on that is making you uncomfortable? Not even necessarily talking about the negotiations, but just helping that self-represented litigant understand the process and why you are staying in joint session. And it may be that you pull them aside and you say, are you uncomfortable? They say yes, and you say, okay, it's time to start doing separate caucuses. But if you are providing information about the laws and gaining information about the facts, and they're sharing it comfortably with one another, joint session can really be helpful in moving the discussions forward.
Maggie, if I could just introduce a statement before I take on the private caucuses. I too am a believer in joint sessions, and most of the cases that I have, if they're business or real estate cases, the people have had some interaction with each other in the past. And if they're there, I've asked them what their goal is. The goal is usually, we came here to settle the case. I get them to commit to that in the joint session. And say, I'll remind you later when we're going to be doing the dance that you committed to the goal of trying to resolve this case, if possible. And then of course you've got to be sensitive to the fact that some people don't like joint sessions at all. They just won't.
Right.
And you don't have to have a joint session at the beginning. You can have a joint session sometime during the course of the mediation, if it's information gathering or information sharing. Or talking only with the two lawyers with the permission of the clients. That's a sort of a joint session between the mediator and the two lawyers. And if I'm on Zoom, I create a Malcolm's Den where I can take them in there. And
the woodshed?
It's not. I was going to say, Ron, it's not the woodshed. It's Malcolm's Den.
Okay. Hey, Malcolm. So let's talk about the private caucus, frequency of use. I mean, I would imagine doing the dance. I mean, that's all what mediation is about. So what are your thoughts on the use of the private caucus?
You've already told the self-represented litigant on the telephone before the mediation session that it usually is divided into three. It's an information gathering and sharing if there's a joint session. And then there's the private caucuses, where I don't use the word caucus, I do private meetings where we'll talk about what we've heard, what we've learned, how this affects you, and talk about what some of your options are. Private caucuses are really important, but I would say this. Remember that self-represented litigants are not familiar with the private caucus or even the private meeting. And if you have had a private caucus with the defendant or the plaintiff who is represented, you have to tell the self-represented litigant what the purpose was of going to talk with them, either first, especially if it was first, because you have the danger that they will build up some suspicion when you are in the room with the other side that, hey, you know, the mediator is in there plotting with them. And you've got to be really careful about explaining why private caucuses are important for them too. And this is when I remind them again, hey, I work for both parties. Other thing is a stay and roll. Do not in private caucus change from your your neutral position, your neutral view, and start giving them advice. It's very easy to do that when you're in a private caucus, because the self-represented litigant is going to use that opportunity to ask you not just your opinion, but what should I do? How much should I take? What should be my opening number? You know, that kind of thing. And look, the primary reason for the private caucus is to have a safe place, a private place where they can talk to you about what they now want to do, what they want to happen. There may have been a joint session or not. There's been sharing of information. Hopefully the represented party has sent a copy of their brief to the self-represented litigant. And by the way, I always encourage the sharing of information, sharing of briefs, sharing of documents, so that at least to the extent it's possible, everybody goes in knowing, you know, what the other sides, I hate the word position. I never use the word position as a mediator. I use the word view, their views of the case, their view of the dispute. So the primary reason to have the caucus is to reestablish the goal. So now what we've learned from the other side is this, and you're going to tell me a bit about what your reaction to that is. But remember what your goal is. If your goal is going to be, as you told me at the beginning, in the joint session or on the telephone, to resolve this case, keep that in mind. So I want you to take your position and put it over there for today. And let's just talk about two things. I want you to think about what your needs are. What do you need to have happen here today? And number two, what's in your best interests? It's a sort of, why do you need to have that happen? What are the reasons that you need to have a resolution in this or that way, whether it's money or something else? And I keep reminding them throughout the private caucus, think about what your needs are and think about what's in your best interests. And we've talked about mediators staying in role and not switching over to becoming an advocate. So there's a difference between doing that and what I call coaching, because I think good mediators coach, whether it's a represented client with a lawyer, but especially with a pro per. And the coaching is talking about, how would you like me to present what it is that you want? Do you have any thoughts, if you've known this other person, about how that will be received? Are they likely, in your view, to be accepting? Are they likely to be dismissive? How would you like me to present? And then sometimes they say, well, you tell me, what should I do? And I'm not going to tell you what to do, but I'm going to suggest that if I just present that number without an explanation, it may not be well received in there. So tell me what you'd like the explanation to be. Or we'll talk about, and this is the coaching bit, consider this message with the number or with whatever your demand is, or if you're a defendant, because we're pro per defendants as well. how the demand is going to affect your business, whether you're going to be able to come up with what they are demanding. Are you going to require time to do it? You know, all of those kinds of stuff. Sometimes these cases are just pure distributive, you know, bargaining. And you may have to talk to them about, if their goal is to settle the case today, how are they going to be able to do that with whatever resources they have, if they're a defendant or if they're a plaintiff. What are your needs? Why do you need to have that? Well, you know, I'm trying to retire and I'm going to leave the state, or my spouse is ill and we need the money, and I can't deal with this anymore. And so what I talk about in that case is what is going on in your your head. And I say, it sounds to me like you are renting some really expensive space in your head to continue to deal with this. Am I right? Am I getting that thing? Oh yes, you absolutely are. And sometimes you'll get the corollary of that, which is, hell no, I'm going to try this case. I'm going to win. And as mediators, we recognize that may be an expression of just simply raw ego. But and you hear that a lot with pro pers, because they're not conditioned necessarily to express it in a way that is not going to be very directive about what it is that they want, and there are no other possibilities. But we talk about what I call dance, and if it's a dollar dance or it's a dance about something else, I talk to them in that term. I say, look, we're now at the dance stage and you own the problem. I don't say, you created the problem. I say that there's a problem here. It's been created somehow or another by both sides. I'm not going to be judgmental, but if you want to resolve it, we're going to need to do the dance. And if the dance is about money, what I'll do is I'll say, look, we'll talk about the money, and my job will be to go back and forth and do take your offer or your demand into the other room, bring it back. And then I say, I've got some other tools if that's not working. And we talk a little bit about that. But what I tell them is the dance will continue until one of two things happens. Either you reach an agreement, which, by the way, as I said before, it's not going to be perfect, but it may be one that you can live with and move on, or you decide that you're not willing to resolve the case today. And then what I do is I walk to the wall and I switch off the light. I say, you have the right to stop the mediation, stop the dance, switch off the light, send the band home. Just understand one thing. You have a window of opportunity here. And that window of opportunity may go away if you choose not to resolve the case. And it's your right not to resolve the case. That's what we have judges and juries for. But
so Malcolm, how about BATNA and whatnot?
Well, the BATNA and whatnot is what we talk about. The best alternative to a negotiated agreement. I say to them, what do you think is the best outcome that you could get unless you negotiate an agreement today? Well, I'm going to win the case and I'm going to get my attorney's fee. Well, wait a minute. We talk about attorney's fees and rights to it. Or they may say, my best alternative is to go and get justice. I hear a lot of, we want justice. You talk about what does justice mean to you. But the best alternative to a negotiated agreement is you go to court, you're able to present your case, the judge or the jury gives you everything that you want. And maybe there's, other stuff as well. And then I say, but, there's another one and it's called whatnot. And I write it out on the board or on a piece of paper and I fill it in and I say, what's the worst alternative to a negotiated agreement? And I ask the open-ended question and see what kind of response I get. Sometimes, well, I don't know. I suppose I could lose. Well, what would it look like if you didn't resolve this case today and you went to trial and you lost? The worst alternative to a negotiated agreement is not something that, in my experience, pro pers fully understand. So we talk about risk. This is where you have the discussion, about risk and the reasons why cases resolve at mediation. Why? Because litigation is really expensive. This is going to cost you money to go forward, whether you're represented or you're not. It's costing you a lot of emotional time in your head to deal with this and be away from, work, family, and all this kind of stuff. And then the biggest reason cases settle at mediation, and I tell them this in private caucus, is the risk. Do you know for sure what a judge or jury is going to do with this when they come back, next year on Thursday afternoon at 3 o'clock? Well, sometimes I'm going to win. Well, okay, so then it's, well, what if it doesn't work out for you? What if you don't? What if you come back with a big bagel after a trial or an arbitration or something like that? A lot of pro pers folks don't consider the risk. And so the private caucus is it's the best opportunity when you've exchanged information with the other side and you can be a little bit evaluative to ask the what if type of question, while telling them you still retain the right to decide whether you're going to settle or not, and on what terms. And then if you're in a private caucus with some friend or parent or someone else that they've brought in, whether it's to help translate and understand documents or anything of that nature, you can turn and look at the person they brought into the room and then look back at them. There's this technique, and you're watching their eyes when they're looking at the person there, expecting some kind of response, some kind of help. And sometimes they will say to you, well, what do you think? Oh, that's a really good point that your mom or your brother or your dad or someone, it's a really good point. Think about that a little bit. Do you think that they got it right? And if you ask these kinds of questions, that's what you do in the private caucus, so that when you are actually being asked to deliver a number and a message with that number, that they know that you've talked it through, and that your job now, because you remind them, we're for both sides, folks, your job now is to bring the information, bring the number to the other side, and then you tell them, this is really important. When I'm out of the room and I'm with the other folks, I promise you we're not talking about the weather. We're talking about your case, and I'm working for you, and I'm working for them, and my job is to try and help you people come to a resolution that makes sense. And if you keep reminding of what your role is, and that you promise you won't tell any secrets, because they will sometimes, well, I don't want you to tell them that. That's the time again when you say, I won't discuss any of your secrets. And the thing in private caucuses that I would emphasize and re-emphasize is you have to be patient, because you're going to hear a lot of what I call venting. There's going to be an opportunity for the pro per to really vent. And as a lawyer, you're sitting listening to, and that's never going to get into evidence. I mean, there's no way the jury's ever going to hear that. But you'd never say something like that. It's, I hear how this has affected you. I really, I get it. Not I agree, or not, oh, I really understand how you're feeling, because you can't possibly understand how they're feeling because you're not in their shoes. And I remind them that, you've lived with this case, or you've lived with this dispute. And I'm learning about it now, and I need you to help me. So be patient, put on your listening ears, and stay away from any kind of judgment or statements like, well, they're never going to agree to that. Because what that does is it generates a belief or a suspicion that you're on the other side, that you agree with them and you don't agree with the self-represented litigant.
Thank you, Malcolm. We have just a few more things to do. It's almost 1:15, and I want to leave some time for questions, if I might.
Sure.
And so perhaps we could move on to the issue of communication challenges, closing the deal and preparing the settlement agreement. Would that be okay?
Yes, of course.
Okay, so let's talk about communication challenges, word content, the formality of your speech, and overall language level. It's so important when dealing with a self-represented litigant that you are speaking to them in a way that they can understand. And so, a lot of times mediators will say to me, do you ever insert humor into the situation? Well, I do, but I am so careful about it, because if you do try to inject an element of humor into a situation that could be considered offensive or off-putting to that self-represented litigant, you will have lost them. But I have also told people, there was discussion just a few moments ago about I want justice. And it always reminds me of a cartoon that I saw in the New Yorker magazine with an attorney in a three-piece suit standing over a beautiful mahogany desk. And this poor woman was sitting in a chair in front of the desk. And the attorney puts his hands on the desk, leans over to her and says, "Just exactly how much justice can you afford, Mrs. Jones?"
I saw it.
Well, that's very relevant, isn't it? Because that gets into the BATNA and WATNA situation in terms of the assessment of risk. Because if in fact they don't settle this case today, which is their window of opportunity, which they may not have in the future, then what is the alternative? Where is this going? Are you anticipating that you're going to have to hire an attorney to represent you if this case goes to trial? And what's that going to cost? And what are the risks that you might not prevail at the time that you go to trial? So those are all things that have to kind of fit into the analysis by the person. And that's the reason why it's important to not be as formal with them as you might be with another lawyer, so that there's an understanding by them that you're empathetic, that you are making an effort to understand where they're coming from, and that you appreciate the fact that this is maybe the most important thing in their life at the present time. It's like Malcolm was saying, because it requires a tremendous amount of mental real estate that goes on and on and on. And people have to be aware of that. And sometimes it's just kind of reminding them of something that they already know. And that hearing it from you kind of brings it to the forefront so that they have an opportunity to acknowledge that and think about, well, maybe I should try and resolve this, and maybe this is not that bad a deal. And all I know is I want to get this over with because I'm tired of it. So that's why word content, formality of your discussion, perhaps the use of humor, those kinds of things can be helpful, but you have to be extremely careful to use those at the appropriate time and place. Let's talk about language barriers. This gets into cross-cultural types of decisions. And I know that you're familiar, both you, Maggie, and you, Malcolm, are familiar with this. So am I, in terms of the kind of work that I do in trusts and estates and conservatorships. But it's sometimes very difficult. And sometimes it's necessary to have that family member or friend there during the mediation session, so that there can be a discussion and that they can ask questions that perhaps the other person may be more familiar with the language that's being used. Obviously, if the self-represented litigant is not fluent in English, this is going nowhere unless you're fluent in their native tongue. So those are all things to think about that you have to give consideration. So let's talk about closing the deal.
Can I just say one thing quickly? Sometimes you find self-represented litigants who actually can't read. They're unable to read, and then they have a hard time admitting something like that to you.
Right.
And you might say a word about that, Ron. We chatted about
Oh,
it.
go ahead and talk about that, because that's something that Judge Barry Good used to talk to us about when we provided this program before.
Right, and what Barry said is, find out to what extent they can actually read or have read the document that may be the subject of the dispute. And oftentimes, self-represented litigants are embarrassed to tell you that they can't read, or they didn't understand what they read. And that's why I think in a way that is not putting them down or judging, is to find out if they understand or if they've read it. And maybe that's when you may be able to help actually read something to them and say, is this what you understood that meant? That's really important, I think. And Barry Good made that point numerous times. It's a great point.
Right, it is. And thank you for sharing that with us.
Sure.
So let's talk about closing the deal and the reticent party. There are times that participants in mediation want to put the success of the mediation on your shoulders. This is your responsibility. You need to convince them that they should pay me this amount of money because I deserve it. And you're not doing this. You're not doing your job. It's your fault. Now I'm being a little bit over the top there in terms of my emphasis. But you get that, don't you? Sometimes when you're getting involved in a mediation, and I have told people, look, this is your mediation. This is your issue. Because at the end of the day today at 5 o'clock, I'm going to go home and have a martini. But you, on the other hand, are going to continue to live with this issue for months and months and months and months. It may be necessary for you to get an attorney to litigate this case if it goes to trial. And so you have to balance what's going on here in terms of the offers that are being made and the counter proposals that you have made back to the other side. And you have to make this decision. You have to own it. You have to be accepting of it, maybe not happy with it, but accepting of it. So what happens then if they say, well, I want to see a lawyer? That's it. If you want to see a lawyer, you absolutely should see a lawyer. I would never, ever try and convince someone, oh, you don't need to see a lawyer. That's not my place. And I think that's unethical. If someone says they want to see a lawyer, it's kind of like their Miranda rights, they have the right to see a lawyer. And typically what I will do is say, if you would like to consult with a lawyer, let me refer you to the Contra Costa County Lawyer Referral and Information Service. Here is their phone number, 925-825-5700. Just rolls off the tip of my tongue, because I constantly will refer people there, because I'm not referring to any particular lawyer, and the referral service will be able to match them up with a lawyer in the area of law, and it's not expensive for them. And so that's the way I deal with the issue of somebody who says that they want to request a lawyer. And then finally, when they talk about, is this a good deal? Well, what does a good deal look like? How would you define that? The issue is, does the deal meet your needs? And that's where all of the things that we have just talked about in terms of the pre-mediation conference and the joint session, whether there is or isn't one, and also in doing the dance and the private caucus. Those are all of the things and the interests that come out, and hopefully we will have assisted this self-represented litigant to come to an understanding of themselves, about what's important to them, about what their interests are. And so, in answering that question, is this a good deal? The answer is it a good deal to you? Does it meet your interests? Does it help to resolve this problem? And I always explain to people that they need to understand that after they have gone through this process and they have made the determination about what to do, that there is the issue of settler's remorse, right? It's going to be tomorrow. when they think about this. Why did I agree to that? I should never have agreed to that. And usually what happens is they speak with a family member, a close friend, and you did what? Why would you do that? And then all of a sudden, this person is unhappy with what they did. So I try and anticipate that that is a very big potential, and try and talk to people about that before the end of the mediation session. That in fact, you're going to talk to people, and you may find other people who don't think that you should have settled this case along the lines that you are agreeing to. But really, again, going back, this is your case. It has to be your settlement. It has to be something that you can live with. It's like the devil you know is better than the devil you don't, kind of thing. And so if they have that kind of an understanding, then I think that helps. Maggie, were you going to say something?
One thing that I found very helpful with the self-represented litigants is to know what the court is doing in terms of how far out they might get to trial.
Oh, Lord.
Because if they've come to you early in the process, and right now when every court is so backed up, you can say, you're going to have money in 30 days or 60 days, and you're not going to have to live with this for the next 2 years or 3 years. And that's one of the factors that you should consider in making your decision on this offer. And it really is amazingly useful in closing the deal. Attorneys, they know what the courts are doing, but self-represented litigants don't know what their future looks like if they turn it down, just in terms of the process.
Right. I would just add, I like to use like metaphors. A bird in the hand is worth two in the bush. If you can get the money in 30 days and move on with your life and not have to deal with this stuff any longer, and not take the risk, take away the entire risk of what might happen at some time in the future. You just got to be careful that it doesn't sound or look like pressure. That's the only comment.
Right. So let's
which is
wrap
which
this
is why
up.
I think you give them what it looks like and say, how does that fold into your decision?
Correct.
Right. So now we've arrived at a verbal agreement with an understanding of how this case should resolve. And now comes the fun part, preparing the settlement agreement. Now, I am going to jump out there and say that I almost always prepare the settlement agreement. And yet I know mediators who will say, I never prepare the settlement agreement. And I understand that. There has been concern about the potential for mediator malpractice or something like that. I don't know. But I find it's easier if I prepare the settlement agreement. If the other attorney has already prepared a draft of a settlement agreement and they want to use that, that's fine. But then what happens is I have to spend time to go over every single item in the settlement agreement that has been proposed by the attorney who is representing one of the parties with the self-represented litigant so that they have an understanding. And that can be a very lengthy and time-consuming process. One that we cannot escape. We have to do, even if you prepare the settlement agreement, you have to be careful to not add terms in there that were not part of the understanding between the self-represented litigant and the other party who is represented. Or you may have two self-represented litigants, So the most important thing to remember is you can't add terms. And remember when I talked about this at the beginning, I talked about whether or not to add in a waiver of 1542, which we would typically do under normal circumstances where you would prepare a mutual release and waiver type of thing. And there'd be a waiver of 1542 and all of those kinds of things. And people would understand that. And typically it's understood that that's part of that mutual release process. But with a self-represented litigant and arriving at some kind of an agreement, you can't inject that unless it's requested by the other side, which is typically the case. And then you come back to the self-represented litigant and say, now they want you to waive 1542. Well, what's that? Well, that means that this is it. It's over. It's finished. even if you come up with something else that you didn't realize was a problem for them later on, you can't go back and open this up. This is it. So again, it has to do with the language that you basically explain to people what these legal things are in the agreement and what they mean so that they have an understanding. Now, what if they say, I want to have this looked at by an attorney? By all means, I will typically advise self-represented litigants that you may want to have this reviewed by independent legal counsel before signing it, because it could adversely affect your rights, and you need to have a full and complete understanding of a lawyer who represents you, as opposed to me, because I don't represent you, and essentially I'm providing you with information that I have obtained from the other side and with my understanding of what it is that they're requesting. But I can't give you legal advice about whether or not this is a good deal for you and whether you should sign this agreement. That scares the hell out of everybody that's a mediator, because you know what that means.
Ron, I have a question.
Attorney.
I have a question on
Let
that.
me finish, if I might, Malcolm. So they're going to go and talk to an attorney, and an attorney is going to say, well, you don't really have to sign this, and you could ask for this, and you might want to change that. And then you might find yourself in another mediation session, which is not unusual, to talk about exactly what should be in and what should not be in the settlement agreement. Yes, Malcolm.
664.6, because these cases come to us from the court, they're already in litigation. And I often find I'm asked a question, well, what if they don't pay? Or what if they pay the first part, but they don't pay, they stop paying after that? And then you've got to talk about, how do you enforce the agreement? And should they have question about security for a given amount of money? These are questions that come up frequently, but if they don't come up, then I have a question of you and Maggie. Is this something you have to bring up, or do you just leave it out there that they get strung out if the other side doesn't pay and they can't enforce, or there's no security for the obligation? How do you deal with that with pro pers?
Maggie, how about you in the employment arena?
I am comfortable telling them that if they're in active litigation when the mediation happens, that there's a provision in the California Code of Civil Procedure that the court can retain jurisdiction. But that's all. I have never suggested security, and I think that would be a wrong thing to do. That's my thought.
In the agreement, do you put 664 in the settlement agreement so that at least they have the ability to go enforce the settlement they just entered into?
I can advise them that it exists. If they then tell me they want it in, then I take it to the other side, is my position.
Okay, and someone asked a question about, or made a statement, I think probably more than anything, that their E&O policy prohibits coverage or prevents coverage in situations where the mediator is writing the mediation settlement agreement. My policy does not have that provision. You should check your own policies to determine what's right for you based on your policy, what you're comfortable with, and what everybody is comfortable with in the mediation session. With that, I think I'm going to end. Yeah, go ahead, Maggie.
Just real quickly, I like to, if one side is represented, ask them to prepare a template as much in advance of the mediation. And then I encourage the self-represented litigant to get that reviewed before they ever come to the mediation. I think it does two things. It gets that hurdle of me preparing to meet the settlement agreement off the table. And it also gets them thinking a lot about, there's a possibility this is going to resolve.
And by the way, the court has a template in the materials that they send. There is something here called stipulation for settlement, and it's got some basic terms in it. Noticeably absent is 664.6 is in here, by the way, but noticeably absent is any other reference to any other statute, including the waiver of anything else.
Right, which is
1542 waivers not in there. 1542 waivers.
So let me see if anybody has any questions. If you do have a question, if you would simply put that into the chat, we'll try and answer as many. We're kind of going over here by a couple of minutes on our time, but we'll try and answer as many as we possibly can quickly. And if we don't have time to continue on with answering questions, if they are in the chat, we will provide a response to you so that you have that. Sarah, do you see any other questions?
I do not see any other questions and nothing in the Q&A.
Okay. So I think that with that, then let me thank all of you for participating in this. Oh, there's one there.
Bob Jacobs. Bob,
Hey, Bob.
Hi, Bob.
are you back, Bob? Are you back?
Oh, that's
So-
right.
So Bob's question is, some mediators think that self-represented litigants come to litigation at their own risk and that advising them of anything almost rises to the level of advocacy. What's your thought on that? So I will start by saying, again, I think that I can advise them of the applicable law if it is an area in which I have expertise. I've been selected because I have that expertise. Then they have to decide, in my opinion, what to do with that knowledge of the law. And I can ask them, the code says thus and such. How does that fit into your facts? How does that fit into your case?
I
It's important for us to try and level the playing field as much as we possibly can without being an advocate. And so that's an educational process. And I look at the information that I provide to self-represented litigants as being more educational in nature than advocacy.
Right. I mean, if they will often ask a question like, what do you think about that? Or do you have any thought? And that's a way of saying, you know, I need you to help me or advise me. And I say, look, my thought is this, or, you know, something of that nature, but never use the word advice or I advise. And even sometimes suggest is maybe going a little bit too far, unless it's, I suggest you take a look at this code section, and then let's talk about it. What do you think it means? But the whole subject is fraught with danger unless you are upfront and continue to remind folks that you are not their advocate.
Right. Also, there's another comment here from Bill Denzel talking about sharing Catherine Richter's statement. And she pointed out, for your information, many mediator E&O policies, including mine, exclude coverage if the mediator prepares a settlement agreement. Be sure you're not voiding your coverage. And I did mention that. And I think that that's an important consideration for people to have. With that, I think that we're probably going to have to close. I want to thank everybody for participating in our session here for mediating with self-represented litigants. I hope that you found the information helpful, and the documentation will be forthcoming. We'll provide that to Sarah so that she can push that out to you in an email. And if you do have further questions and you would like to send those to us, feel free to do so. It was a pleasure putting this together and also working with two very wonderful and experienced mediators like Maggie Grover and Malcolm Sher. And thank you very much.
Go forth and resolve.
Thank you, Maggie, Ron, and Malcolm so much. And thank you everyone for attending today. Keep an eye out on your email for the materials and your certificates, and have a great rest of the week, everyone.
Bye-bye. Bye-bye.
Thank you.
Bye.
Bye now.